All right, so I paused in part to look at an email that we've just received from the Queensland registry, and I'll talk about it in a moment, so we don't get distracted. But anyway, the point is that the orders that the Legal Services Board had sought in terms of the listing of the matters were that here we go. Basically, we should get 1 day, half a day, for the start from scratch to the conclusion of the contempt trial process, and no directions at all about anything, and obviously no discovery or subpoena or any of this stuff. And then, either she really fucking hates their guts and wants to nail them without due process, or she is really in love with them and wants to protect them at any cost. Anyway, so now, for contrast, the orders that we had sought were that so the orders we had seen urgent listing of the matter, because so that day when they had scheduled the hearing at the last minute in the 642 proceeding for an interlocutory application, we had to send our material at the last minute. The court didn't receive it. When I say the court, the registry had received it, but Justice Marr, who was presiding over the matter, did not get access to the documents from the registry because of technical issues that Her Honor has referred to in her judgment.
Yep.
Now, so I couldn't make the application or respond to their application without the evidentiary documents we were going to rely on, because their argument was that they're trying to, go about their statutory functions, and I hate their guts, and that's why I want to stop them from doing their job. And if anything, just ask Gordon. So that was basically the essence of their thing. And when we tried to rely on all the evidence that we've collected against them, including an integrity oversight Victoria investigation of the IBAC's improper collusion with the LSP, effectively through the improper disclosure to them of complaint that we had made against the LSP to the IBAC. Anyway, so all of those things that we've already filed in evidence. Gordon himself has found that there was potentially a malicious defamation committed against you and me and potentially Lulu if the appointments were unlawful through the way they colluded with the Legal Services Board. This is in the same judgment through which he, basically tried to get rid of every relief measure that could have exposed him. So we try to put that evidence before Justice Marr, and Her Honor hasn't received the thing. It's around 8 or 9 p.m. at that time, between 8 and 9, and we say, well, this should continue tomorrow. Because we don't want to continue without Her Honor getting the evidence, and it's like copious amounts of documents as well. So that's what we say. Her Honor, we say there should be no interim order. I know that if she didn't make an interim order, then it would have been the same as dismissing their application altogether because it was for interlocutory injunction. But their application could not be made at law. It was seeking to suppress public political speech, which there is an implied freedom for under the Constitution of the Commonwealth. So, and ironically, the lawyer presenting the argument, Kathleen Foley, she went on Four Corners to talk about how the Attorney General at the time, Christopher, I'm really bad with names.
I know who you mean.
Porter,
Christian Porter, that's right, the Attorney General, yes.
Christian Porter didn't just become a scumbag in her, well, it was the essence of what she was trying to say. After he became a minister, he was always degenerate. And she knew him, back in the university days when he did all sorts of improper things. That is what she's saying about this man, who is already, 10 feet underground because everybody else has taken a shot at him. And for that, she gets immediately appointed by the local government, Labour government here, for taking character assassination shots at not just Porter, but another person. So, and she said a number of things about High Court judges, in relation to allegations of sexual misconduct by their associates. And not just the people that were accused, but also other people who she says did the wrong thing in not basically going after them publicly. And she also says that if they were doing it to protect their rights, they should have said that the only reason we're not publicly attacking these people is to protect their rights. That was her. Anyway, I don't have anything against her making those allegations. And, I am progressive myself. I don't like the current government because of the whole corruption thing. But the problem that I have is the hypocrisy of it, like coming to us and saying that if we raise the concerns that we have in court proceedings, it would scandalize the administration of justice, which, by the way, has been left completely unscandalized, despite her, attacking the fucking Attorney General, the law officer for the country, in a completely fucking, the way it was set up was also wrong. What I do have a problem with is the fact that she's, profiteering off of the misery of other people, because she wasn't if she knew him from the beginning, why wasn't she the first person to come out and, raise these issues?
Understand what you're saying, yeah.
First, she waits for people to, risk whatever they risk in making allegations against powerful people in public. Whether or not they're true, that's a whole different thing. But at least there's bravery in making those allegations. And then she waits and sees whether or not they succeed. And then if they've succeeded and the person is, long buried, then she'll come around and say that, yeah, that guy was a real scumbag, So that's the person who was opposing who was presenting the case, that in disclosing or using that evidence, we would practically be in contempt of court because it would debilitate the functioning of the Legal Services Board to the extent that it would inevitably give us an improper advantage in all our multiple proceedings against the Legal Services Board, which is, sorry, have I lost you?
No, I'm here. Can you see me?
Yeah, I can, sorry.
Yeah.
Something came up. And that the debilitation of the Legal Services Board because of which we will benefit in court proceedings is the only purpose for which we want to raise these allegations, not what we're saying is the purpose, which is that these people are unfit to make the decisions that they're making. And they made decisions against us when they were unfit, demonstrably unfit. So now, obviously, Justice Maher doesn't want any of this stuff to be heard properly. So, and she knows what happens to judges when they try to, corruptly prevent me from raising those allegations. So she's taken a novel approach in basically preemptively scheduling matters in a way that I don't have time to raise those matters. I mean, if I was going to say if she put that much thought into doing her job properly, maybe she could cheat better, but there's not much thought that goes into it, actually. So anyway, so we're asking, this is the email that we had sent, and we said we need 1.5 day listing, and we need at least half a day to cross-examine their lawyer, who basically gave evidence that he had heard from Matthew Anstey, who had been told by the person who was the alleged, well, not alleged, they've actually accepted it, who was the unregistered sex worker, that it's not going to be, the best thing for her if, for instance, her husband and other people knew that she was doing this. So, therefore, the court should, stop the evidence of her bad character and her unsuitability to be a lawyer. The court should not hear in open court and stop us from doing it by an injunction under common law. Well, it's an equitable relief thing, but they're not relying on this particular statutory provision, is the point that I'm making. But through an injunction to prevent a threatened contempt of court. Now, there's authority that you need to satisfy the beyond reasonable doubt threshold twice for that. Once that there's a beyond reasonable doubt that if the court doesn't grant the injunction, then that will happen, that certain conduct will take place. And that there's a beyond reasonable doubt that the conduct that then takes place would be in contempt of court. That's the threshold they have to meet. And their application is basically, we can't conceive of any other reason but the fact that you want improper advantage in court proceedings. By the way, that person, not a witness in any of the matters, not even the instructor in any of the matters. It's just that she's really fucking precious to them and they'll be heartbroken and so sad that no one could work at the Legal Services Board. And that's how we will gain an advantage in court proceedings. So that's the matter in which we said 1.5 days. And we said we wanted to cross-examine him and a bunch of other things. And their response is that no, half a day, and that's it. And that is without listening to anyone.
Yeah.
Half a day. So then she makes the orders, and now they've said that they want these matters to be listed in this way. And now she had already ruled that she wants to hear first before our interlocutory application is decided. Okay?
Yes.
We had initially filed the interlocutory application under criminal provision because of the contempt thing. The registry got back to us and said that it's not a criminal process that we need to file it under. It's the civil process. We disagree with it, but we would have filed it right after. But there was no point because she had made orders that she would first receive submissions about whether or not it could be listed. We didn't even know whether it would get sealed, right? And then they say that they've not filed the interlocutory application. We had filed it initially, lodged it rather, and they got back and they said this is not the criminal process, it's a civil process, even though contempt is a criminal charge, but it is conducted through the civil procedure. But in the Supreme Court, you file it under the criminal process still. So that was our experience. And anyway, so they say that they can't see it on the list of filed documents through the registry. By the way, there's other ways of filing the documents, for instance, by email. But they basically say that they conclude that we haven't filed it and write to her, and then she doesn't ask us whether we filed it or not and why we've not filed it or any of that. She says they've not filed it. She gives us less than 24 hours to file it, business hours, I mean. So on Friday, she says that basically if it's not filed by Monday, she's summarily dismissing the application, which, there's no fucking basis to. And they didn't even fucking ask for this dismissal.
Yeah, no, exactly.
I mean, whatever they promised her, well, there's no point in asking because we couldn't promise it anyway. But the point is that she says here, basically rubber stamps whatever they're saying, and then says she's drawing our attention to the obligation to serve the Attorney General and all of that, and give help her in fulfilling her duty to give the Attorney General an opportunity to intervene. After I had lectured her about that, albeit briefly, and then she basically says everything is listed for half a day. Not just the contempt, sorry. I have been saying contempt application for half a day, but it's not just the contempt application. It's also the separate determination issues that we had raised. And like the issues being, let me just bring up the constitutional notice. I mean, it's a good thing that she fucking conceals the record of her misconduct, because can't help anyone anyway. So this is the constitutional notice that we filed, and in the interlocutory application, we said that these matters should be determined. So basically the matters are that if a judge who has communicated with the other party, who is then called a scoundrel and, so corrupt that you couldn't bribe them to make them more corrupt, so ostensibly corrupt that they couldn't have desecrated the administration of justice any further, even if the criminal conduct had been secured by bribes, and a scourge on honest judges anywhere. Those were the things that I'd said to.
I do recall.
Justice Cotd in open court proceedings to him, and in his honors reasons, he said that it was just euphemism for the affectionate nicknames that I had for his honor, because I disagreed with his judgments. Whereas what I was saying is that it's not that I disagree with his judgment. I think that he's a criminal. I literally said that to him, and that he's a bigger criminal than the criminals that we're prosecuting. And again, a lot of people tell me that I shouldn't use loaded terms like that because it makes me sound less credible. But the reason why I do it is because technically the conduct fits. And secondly, I was at a hearing several years ago, Sunshine Magistrates Court, sorry. And there's this young black kid, teenager, school going. He was in his uniform. He was brought to the court, and there's this police constable, I presume, who was going to charge the person.
Mm-hmm. Yep.
And when the charge against him was read, this guy was so shocked, and like he felt betrayed that the other side was setting him up, and he was alone, obviously very intimidated, and he didn't even bother explaining his view or his side, because he understood that it wouldn't make any difference. So the magistrate is then addressing him, and he puts his fingers in his ears. And it was so. I mean, anyway, and the fact is that people like that don't get to raise the arguments that I raise, because I have the resources to get other people to research a lot of things, and I have the determination to learn a lot of things, and I'm interested, and I've found a way of making this my career. But those people will only be able to use simple emotive terms based on how they feel. And I want to stop this automatic perception that anyone who accuses someone in authority is automatically illegitimate. I mean, you have to, there's all sorts of protections built in for judges. And I do it in the most fucking confrontational way too. I do it to their face, and I then urge them to fucking charge me. And when they don't, I write to their chambers and tell them that they're, fucking scoundrels, and copy the attorney general in. So they would charge me if anybody had any confidence in in their character. And they have all the protection built in. If I'm illegitimate, I should be charged and prosecuted.
Absolutely.
But, so someone in Lang versus ABC, the High Court said that because everybody relies on disclosure of corrupt conduct, and everybody benefits, and everybody has an interest in receiving that disclosure, therefore everybody has an implied duty to engage in that. So that's why, by the way, I feel that it's particularly, I mean, I grew up very focused on my academics, and I didn't swear at all until I started my first business around 25, and it was in accommodation services. So a lot of the people that you had to work with, they only understood that you were angry if you said fuck. And then I realized that it was necessary. So I thought it was immoral to swear up until a little earlier than that. And then I started doing it because there was an imperative. And after that, I had to deal with a lot of lawyers and judges. And I joked that, Maria used to say, he says he never swore until he started dealing with lawyers and judges. But it ramped up way more then, not because they, well, I should say, not just because they will only listen if you do, but because it is forbidden. and I want to break the taboo. So, we have these young lawyers working, and there is an automatic bias and psychological block that, how do you challenge the judge? When they're doing the work that they're supposed to do, most of our work is basically finding fault in what the judge is doing. That's what we were setting up to do. They cannot think critically. They cannot microanalyze and try and find fault with everything that the judge has done if they are so fucking awe of the judge. And, if they're enamored or whatever by their status in the process. So the moment I would find an opportunity to criticize, I would fucking, go at them hard, because I wanted to break the fucking psychological blocks that these people had and make them understand that, if you punch a judge, you just get prosecuted for the same sort of assault that you get prosecuted for if it's anybody else. I say punch for the shock value of it rather than any other thing. But unless you're doing it to stop them from, carrying out their duty, which is a contempt of court, and it's a whole different thing. But the point is that the Constitution does not place them any higher than, any other person. And then once it just feels wrong if you are like that behind their back, and then you're trying to be overly, different when they will know. So to be consistent, I am just as robust in my criticism. And the other point is that I think that I'm very critical of everybody, and I don't go to people's houses and say that they should adopt my worldview or my principles, but if they come to my workplace, nothing else matters but the work. And like I say, no better place to die than at work. And it's just so fucking cowardly and duplicitous and wrong to go after people who go after you in return because you have high standards at work and you want them to comply with those. But when these fuckers, screw up in matters related to your work, then you don't criticize them just as effectively because you're scared of I don't know what. So that's why I think, for all those reasons, it's important that that they're criticized, even though I know that in doing so, I have to work extra hard to then convince some people that there are legitimate points. But all of this is a ideological exercise anyway. So yeah, I mean, there was a slight distraction there, but the point is that we have these very fucking complicated constitutional questions that need to be determined. I mean, it would take fucking half a day to read them.
You're not wrong.
So it's just ridiculous. This is like one of 5 things we're seeking, and she's listed everything on the same day.
I get it.
And well, in fairness, she has admitted to never reading any of the stuff that we've sent to her, but I don't think it helps her case too much. So that's basically the thing. Now, I think, though the LSP doesn't get this, but ultimately, they may end up being the worst victims of judicial corruption, because the corruption only helps them if it basically stops us all the way through. Because if it just fucking oppresses us and delays things, but ultimately you get an honest judge, then they've made so many fucking admissions, and like this fucker, not that he had, this is Jared Heath from Course, the solicitor for the Legal Services Board. Not that he had a right to have a say on whether or not the court should hear our contempt application about how his client has perverted the course of justice by intimidating the lawyer who was giving evidence about the unregistered sex worker and so on in our proceeding. So they contacted his lawyer and basically asked him to threaten him with abandoning his legal representation just before hearings, including disciplinary recap that the LSP is bringing against him. I mean, he says, and it seems like they are completely frivolous charges because they want to silence him or at least destroy his credibility by labeling him all sorts of things. Anyway, so they lean on this lawyer and Stephen Walters, and then Stephen Walters goes and writes to the lawyer who had disclosed things to us to say that, don't give them any evidence. And the lawyer forwarded that communication to me. He made statements. He's even given an affidavit now that is what happened, and it's been lodged in the 642 proceeding. Justice dutifully prevented us from finding that evidence in this proceeding, and I'll get to that in a moment. But basically, all of that stuff listed for half a day at the LSP's request. I mean, this is how confident they were in her, that they said the objection that she had given them the unlawful entitlement for, they didn't even need that. They were like, no, all good, so long as you're dealing with it. So the problem is that only helps them if she stays all the way through. And
understood.
Otherwise, they've basically waived any objection that they could have raised by admitting the propriety of the cause of action, effectively. So let's see whether she can justify all the things we're saying against her, or at least charge us with contempt, or me at least. Now, she makes these orders exactly as they asked, and I mean, she's from Queensland, so it's not even that the Legal Services Board sort of inserts a chip in lawyers. So even when they become judges, they basically remain under the control. But I mean, unless she migrated from here. But I think her father was a judge in New South Wales, so I don't think so. Anyway, the point is that I write to her then. So this is the email, the cover email through which the orders were sent. She says, she reminds us that, what I've told her, which now the LSB has confirmed is right. I should do the service on the Attorneys General. That's all she says, that they need to be served.
Yes.
And then she says, because the applicants have agreed to have these matters listed before the creditor's petition, this is the best part. This is the best part. Because I will do everything I can to have an honest judge in this matter, and at least this will remain for them. That they, as the applicants have agreed to interlocutory application being heard before the hearing of the creditor's petition. I mean, she's technically a judge, even if not really in the way she's ruling this. But she has affirmed that they have agreed to the contempt application being heard before the hearing of the petition. Therefore, no longer require submissions and blah, blah, blah. So she makes these orders. Okay, now, we had said 1.5 days. We had said we want to cross-examine him for half a day.
Yeah, I recall.
We had said that the application must be this. So this isn't, again, I keep getting distracted, so I never finish this. So Justice Marr basically adjourned the matter. She said, would you give an undertaking? I said, obviously, they were trying to imply that the sex videos that person had, the former unregistered, okay, also I must clarify this. I've been constantly saying former unregistered sex worker. I mean, that's my presumption. I think there's only, again, I was going to make a mean joke, but it would be unfair to prostitutes, so I will not. But the point is that I'm presuming that she's no longer a sex worker. She's too busy screwing people up at the LSB anyway, so I'm not sure if she gets any time. But anyway, I presume that she's a former unregistered sex worker. She had sent videos to the person who made the disclosures to us. He forwarded those videos to us. We have been very clear that we will not publish those, but we will give copies of those to the IBAC as part of the complaint that we've made to them. And when the IBAC screws up, as they always do, then in support of the complaint against the IBAC for screwing up that investigation to the Integrity Oversight Victoria. And then when they screw up again, as they do, to the Parliamentary Oversight Committee. And we repeated that in front of Her Honor and said that this is what we can definitely commit to. Unless, they can just basically confirm that the content of the videos is what it is. I mean, I've never actually seen them, but I got Thomas to describe them, so I don't have to. And he did. So all our position is that so long as they accept that this is what it is, they can fucking nuke the storage devices in which they are. But the fact of what she's done should be documented somewhere. So the judge was not happy because that would be dismissing her application, but obviously she wasn't going to stop us from criticizing anybody there. So she basically made an order, the effect of which is that we can't name the person against whom the allegations were made. And to be abundantly safe, we're not even naming the complainant, though there is nothing that would stop us from naming the complainant. The irony is that they were basically using the public thing as an excuse. I mean, everybody knows that they're fucking, everybody knows who, I say everybody, but at least everybody that I've spoken with, which is a considerable number of people before the order was made within the legal profession about this, they knew about that. I mean, you say that, do you know that there's such a person? And they're like, she, okay. We don't know if she was exactly this or that. Present evidence of that in terms of correspondences with people in the proceeding. Well, I tried to. Downs has gotten the registry to reject it, which I will address later. But people know, the public knows it's in the public domain. They really didn't give a shit about that. The whole thing was about preventing us from filing the evidence in the Supreme Court and in the federal court. And I pointed out, which Her Honor has included in her judgment, that the federal court couldn't stop me from filing the evidence in the Supreme Court. So what they also accepted that was the case after Justice Marr asked them to clarify. And their point was that, yes, they know that they can't legitimately stop me, but what they're doing is they're trying to get the court to stop me from taking the specific logistical actions that would be necessary to the filing of the evidence. I mean, this was Kathleen Foley, the person who thumps her chest at High Court judges for not crucifying their colleagues before they have been properly found to have committed misconduct. So anyway, I mean, the members of Victorian Bar have a right to know how rotten she is, because she stands for elections there. That's what all the authorities talk about, the political, implied freedom of political communication part. So Her Honor ultimately grants that interlocutory thing. We think it's, she says that she will grant it. She never makes the order that day. We thought the hearing was being adjourned to the following day. She basically disappears. I think, honestly, without exaggeration, she was embarrassed by the fact that she had indicated already that she would make the orders, because she clearly didn't know the authorities that was citing about the implied freedom of political speech and so on and so on. I mean, it's a very specific niche area of law. It's not the sort of thing that you would normally come across every day. And also, it's the government that's doing it. And I say this in concession to Her Honor's, the position she was in, but not that I think that she should have relented. But I think as a human being, you're in a position where one side is saying that our side will be basically slaughtered and massacred if you don't fucking intervene, in the sense that, there'll be things about her published or whatever. And if she doesn't immediately accept the submissions that I'm making, the technical legal submissions, even though they're clear, then the potential for harm to them to her is pretty serious. I mean, the other thing I pointed out that day, and Her Honor has included in the judgment, is that the person for whose benefit they were seeking the orders should have been a party. Again, very well established in the authorities that she needs to be a party. But, it's sort of embezzlement too, if you think about it, because they're prosecuting through public funds and, hiring all these corrupt hacks to make the arguments to the court for the personal benefit of an individual. I mean, it's no different from just giving her the money to hire a personal lawyer. It would be more efficient and less corrupt. So anyway, she granted the orders and then she disappeared. And as it turns out, she'd recused herself effectively, though she never officially said that in her judgment. And then, since then, there's been one recusal after the other, until, they struck gold with Justice Downs, who really doesn't give a shit about the fact that the court has made an interim order of an uncertain duration. I mean, the court is not supposed to fucking suppress the record or make a suppression order and a pseudonym order without actually hearing the matter on the facts for an indefinite period. That's like it's constitutional law 101 that, I mean, if they can just keep the opposition from raising, arguments against the government for a week before the elections, then that's the end of democracy. But
well, Ma did say it was to be heard urgently.
Exactly. That's the other thing. Her Honor, to her credit, also made orders. I mean, she obviously did not anticipate it, that Justice Downs would come to their rescue. But the point is that I was distracted by, like if the complainant who provided us the thing was there, he would have said, maybe Downs was a client. Again.
And as you said, it was only part heard.
Exactly. And again, not the right thing to say, because what Downs is doing is horrible and should not conflate that with less horrible things like, what is being said about the other person. So the point is that Her Honor made orders that it be listed for an urgent hearing, wasn't listed for an urgent hearing. We reminded Justice Downs, couldn't give a shit. Obviously, because the LSP wanted it to be listed much, much later. So now I write to Her Honor and I say, we request Justice Downs to provide reasons for Her Honor's decisions delivered via the attached email, which I forgot to attach, by the way. We further request that Justice Downs provide them at her earliest convenience. Whilst we consider it inappropriate for Justice Downs to make decisions in the matters before hearing us regarding Her Honor's disqualification from the proceeding, we note the oppressive effect of the orders and the imminent threat posed by the self-executing order Her Honor made, blah, 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 blah. It is self-evident that the purpose underpinning the orders is to create an arbitrarily strict qualification to the exercise of rights and privileges that are available without restriction, except that they may not be abused to create oppression for others, to litigants in hearings conducted by competent, independent, and impartial judges. So Lulu did this thing about, she keeps complaining about how my letters are too difficult to understand unless people really pay attention and so on and so forth. So she asked ChatGPT to critique my writing. And it was interesting what it said. Anyway, so say all of that and also point out that they have the implicit effect of determining the respondents may not call any witnesses or seek any other orders in the proceeding. The appropriateness or necessity of such measures ought to have been raised with the parties when Justice Downs first considered them. Okay? This is an application for her disqualification on actual bias. Yeah, this is what it is.
Yeah, absolutely.
It sets out how she's made oppressive orders and only for their benefit and all of that. So we say that, and we say that we will lodge an interlocutory application, and can you please set aside sometime on the 30th of June or earliest thereafter. And then we say, you know, we just want you to waive compliance with one order because she had made a self-executing order that effectively, I mean, she wasn't honest enough to plainly state that it was as such, but it was just like when she said, I want you to tell me why, give me legal submissions, why 9 comes before 10 and not the other way around. But anyway, clarify to her that we just want her to suspend the operation of that order. But otherwise, you know, let's schedule a recusal application at the earliest and we will file a application, not again, just so she doesn't fucking pervert this or distort this again. What I said was not that we will file the recusal application, because you don't need to file it. It's raised informally. That's the law in this country and common law countries everywhere. Because, you know, just in case that you shouldn't have to wait for paperwork while a judge is committing corrupt conduct in front of you, because it fucking destroys the whole concept of a judicial system that's independent and impartial and competent. Anyway, the application we said was for an urgent listing of the hearing, not for the recusal, but for it to be heard urgently. And now, if you think about it, we've said that we want that urgent application. We only need to ask her informally. She knows. We've even fucking given her the grounds. Yeah. And we say, can you please set aside some time on the 30th of June, or, you know, whenever you can after that. And we also say that if you just indicate that you will, we promise to file the application by this deadline. She gets back and she says just this. Please be advised that Justice Downs' reasons for the orders made this morning are as appears in the content of the email sent with the orders. So all the stuff that I raised about listing everything for half a day when we were asking for one thing to be listed for 1.5 days, about, you know, why, basically how the subpoena will be decided, because we needed the documents we were subpoenaing in support of some of the relief measures that she listed for that day.
Absolutely.
All of that stuff and more, everything appears in the email. I mean, at least she knew that she was fucked and didn't embarrass herself more by, you know, making up more lies like she did with the last reasons, in which she accused us of ex parte communication without ever fucking point. I mean, it's just fucking, she's basically making allegations against us that we can prove of conduct that the LSB is incriminated in relation to basically, you know, muddy the waters and delegitimize the evidence of corrupt conduct that we have gained against them. So now she says the reasons are there. So I say thank you for clarifying that that is all that she was going to say about this. I mean, you know, you couldn't fucking... The one redeeming feature that most corrupt judges, if not all, generally have is that they're too fucking lazy to... I mean, that's one of the reasons why they are corrupt. They initially screw up and they don't want to admit fault. And then the people that they have to curry favor with to avoid accountability, they then want things in return, and they have to then be even more fucking dishonest. But laziness is a big part of the thing, and that's the one redeeming feature, because this way they can be taken down a little bit easier, well, much easier actually, than if they were meticulous. Anyway, the point, by the way, I think I should point this out, that, you know, there's a there are evolutionary biologists that have used complex game theory principles to demonstrate that the whole concept of evil geniuses, it's not really built in the real world. I mean, there's far more people that are really bright and gifted that work on the right side than the other way. And they demonstrated why that is so based on the adaptive benefit principles of evolution. Basically, they're in a coordinated adaptive benefit arrangement with society. And because it's in the interest of society, you will always have a proportion of people that are really bright, even though they overall tax the community more and all of that stuff. But basically, because those people who need the community to help them survive anyway, because they're really bad at other things and they're outnumbered, they are generally useful to society, and that's why they consistently exist. So what I'm saying is that it's very unlikely to have extremely meticulous and dedicated corrupt people because of genetic reasons. Anyway, we then, on the 23rd, we launch an interlocutory application different from the one that she had ordered us to launch. But, you know, we exhibit that. So the interlocutory application we launch basically now seeks an urgent listing of the recusal application. That's the first order, and then directions in relation to the other matters. And that, you know, we should be able to issue the subpoena. sorry, this is the interlocutory application. It says, if the court is unable to schedule the hearing so first it should schedule the hearing 30th June or the earliest thereafter. If it's unable to go by this date, then, delay the other hearings. Then the order sought through the original interlocutory application be taken to be sought through this one as well. And the court lists a directions hearing to give directions regarding the filing of the material. And the listing of a hearing concerning the original interlocutory orders. She would basically decide everything on the day from the way she's been. And then this is a declaration in relation to the filing of the contempt application, which they had rejected the way we had first filed it. And then that the order made in the other proceeding about the conduct of this proceeding, specifically the allegations about the former unregistered sex worker, that document should no longer be suppressed from the public record. We were never heard. We were not even on notice. It was just, made because Kathleen Foley said today is the board's birthday, and this is what they want. So, well, I shouldn't say that because Justice Maher maybe made errors, but she didn't actually act like she was deliberately being dishonest or even reckless. So yeah, okay. Now, that's the application. We send it to Her Honor's chambers at 5:15.
Yes.
It's lodged at like 4:25 something, and 5:15 it's sent. And the affidavit basically says that, I'll bring up the affidavit. This is the really interesting bit. So this is the affidavit. And all it says is that we've lodged some exhibits. They're available on YouTube, on our YouTube channel. And these are the specific files. It's basically discussions between us. And then some documents which form the basis of the analysis which we've conducted in the recorded discussions. And that because of the way in which she's conducting the proceedings oppressively without giving us any time, blah, 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 we never got the opportunity to put those matters to her. I mean, we had asked her until Wednesday to properly file the application. Basically, someone would have, the process is that I document these things for the podcast that I'm planning to start imminently and have been planning for a while. And in relation to the preparation of the cases, people working for us, they transcribe those things and then extract the relevant parts, which we then put into the documents. And it serves both purposes. She didn't give us the time to do the other thing, so we said that we will just put those recordings in as proof of they discussed the case, and the evidence that referred to in there has also been filed here. But also it was evidence of the volume of matters that we wanted to raise, and from that the court could infer whether or not we were being given adequate opportunity to raise those matters. That's all it says. It says this folder, complaints against Townsend and complaints against Cotd, contain my discussions with Mr. Ansel and Nishu and other people regarding my analysis of the decisions made by Downs and Gorton, and in proceedings against the Legal Services Board. The other documents exhibited are the evidence and other information upon which the analysis captured in those recordings has been conducted, and then all the factual assertions made through the documents contained in the large folder that contained those subfolders are accurate, and all my views documented in those documents are sincerely held. As the documents demonstrate, Downsday unjustly and unjustifiably sought to prevent me, my associates, from filing interlocutory applications and seeking relief, blah, blah, blah. A meticulous documentation of our preparation of the cases and related matters is part of my work in producing reports about the injustices faced by. I mean, this affidavit is so fucking vanilla, I mean, I generally I don't write in an overly provocative way as I speak, because different purposes. Anyway, the point is that there's nothing controversial in this document. All it says is that we were treated unfairly. This is the document that was lodged. The other stuff was shared via a Dropbox link and YouTube. Now, the registry only sees this document and they seal this document. Okay, everything else comes to them after the document has been sealed.
Yes.
And what happens after we launch this document is that, so 5:15, and I send the link. Now, the way we share the documents is designed to notify us every time someone downloads and give us some information about who's downloading. So Her Honor's Chambers downloaded these documents, viewed them, and remember how in her judgment she said, because the application had not been sealed and all that nonsense, and that's why she wouldn't list it. And then forget about that even. I mean, we've basically here made an explicit application, said that this is the horrible things that she's done and its impact on us. We need an urgent hearing. Didn't fucking address us. Didn't address us about the recusal. I mean, not only did she, it's worse than not addressing. She addressed the email and specifically ignored all of that and just said, fuck off. She can't be bothered giving proper reasons or, what can you do about it, sort of thing. So we write back to her and we say that, can you confirm that she's not going to give reasons or give reasons, because we especially need to work on it over the weekend. And again, if she had clarified things over the weekend, and I clarify here as well. I note, okay, I attached the thing. Please confirm if Her Honor will accede to our requests regarding the suspension of the operation of the orders and giving us some time to file the interlocutory application, because we need to sort of start work on it through the weekend. Say here. We'll be grateful if Her Honor could respond today, as the timeline we have proposed is on the basis that we would work on the matters throughout the weekend. Otherwise, we have urgent other matters to work on. Doesn't do that, and then she's made a guillotine order for Monday. So we filed the thing, including the last video that we had produced as an exhibit to the thing in the Dropbox folder. Now, the registry doesn't download it. Her Chambers downloads it. And obviously, the application has not been listed. The application cannot be listed as an urgent hearing without evidence in support. Anyway, I mean, you don't need to file evidence formally to raise a recusal application, but you do need it if you want the recusal application to be heard immediately. And what's notable is that she never gave a shit about us requesting an urgent matter. We've been asking for a long time. And also, she's so fucking stuck up on the stamp of the fucking registry before. I mean, she doesn't see the application, she said to me. She doesn't read anything. She only reads it if it comes as a sealed document through the registry, or if you are the Victorian Legal Services Board, and snap your fingers really loudly. So 8 o'clock the following day. So we provided to her chambers after hours. 8 o'clock the following day, she's listed the application. I mean, the registry hasn't fucking had the time to even see the applications, because filed at 4:25, the registry closes at 4:30. I think the federal court rules require, 4:30. But really, all the orders say that you should file things before 4 o'clock. Anyway, so she says that it's been listed half a day, MS Teams, blah, blah, blah. Now, we've shared the thing through the Dropbox folder, which is downloaded. It would seem from the information that I got from Dropbox. The registry hasn't. Also, it's none of their business. They never do. You don't even need to give them the link until they seal the affidavit. You give it to them afterward. They don't even have a basis. They can't store the documents anywhere until it's been downloaded. So, and it's their policy not to check affidavits. It's part of because they don't have any purview under the Evidence Act. So now I'm very surprised because she listed the application even before it was sealed. And I just want to make sure that she's not confusing me with an employee of the Legal Services Board. So I write to the registry to inquire about how it is that this one. Yeah. So 10:45 a.m. No, this is not the one actually. Maybe it's different shade. 1 second. So here, I write to them at 10:16. Mr. Kemp, I know that the interlocutory application, the registry hasn't processed, but it's already been listed by Justice Downs for hearing. And then I say, this further gives rise to the appearance of arbitrariness in the administration of the court's affairs, so as to justify an inference that the sole point of having unnecessarily technical rules, along with the discretion to suspend their operation at will, is to weaponize formalities when it is necessary for the repositories of the statutory discretion to pursue an improper agenda in conflict with their duty to further the cause of justice. And I provide them a link to the folder as well. They don't download this. I know because, I get notified if they do. Then at 11:52, the registry writes to me and they say that they have accepted the urgent application for filing, but rejected the affidavit. At 11:52, the 24th of June. Also, the rejection took place the day before. So they're implying that she only listed the application after the registry had approved it or sealed it, and the affidavit was rejected by the registry legitimately. Now, I don't know how anyone can say, so by the way, This is very fucking hurried for the reasons why it's rejected. And it says, this is what we filed. And 2.26, Rule 2.26 of the Federal Court Rules allows a registrar to refuse the lodgement of a document, including an originating application. This is meant for basically pleadings and originating motions to be rejected if it is frivolous or vexatious on the face, blah, blah, blah. I referred you to an authority yesterday, which basically says that this is not a judicial decision and they don't actually get to decide if it's an abuser process. They can only decide whether on the face of it, the document complies with what would be the common English meaning of the requirements for lodgement. So for instance, you don't start the proceeding that someone has robbed you if they've stabbed you. That's all they can check. You know, not nuanced issues. But anyway, the Evidence Act is not within their purview. And so then he explains what frivolous and vexatious means to me. And then says, on the face of the affidavit, I'm satisfied that it contains material. The affidavit contains material, not the exhibits, on the face of the affidavit. So he doesn't say any document exhibited to it, on the face of the affidavit. He doesn't have access to any of the documents, by the way, which is clearly vexatious and is an abuse of the court process. Now, applications are vexatious. Even this authority that they've cited clarifies that, not the evidence. How do you accept the application and reject the evidence as vexatious? I mean, that is oppressive.
Ludicrous.
And that's why they've reduced it. Reduced to seal it. Accept the filing of the application, not vexatious or frivolous at all, but the evidence is, and he says on the face of it, not any documents exhibited to it. Now,
well, you said they hadn't received the documents.
No, and it's also not his job to check.
No, absolutely.
Discrimination under, it would be unfair treatment and violation of a number of human rights if he started specifically checking the exhibits for us and doesn't do that for everybody.
Well, one aspect of it, we wouldn't need judges. We've got registrars to decide these matters. I'm being flippant.
I know, but I think the Legal Services Board has already taken care of that. So, you know, but I honestly think that at the very least, if the Legal Services Board could just be honestly dictatorial, then at least people would be spared the cost orders that they have to incur additionally when they sue the LSB, ultimately to have nothing done against it. You know, I mean, at least that's the worst part of it. Like, people like Downs and Gorton, not only are they fucking, you know, looking after the criminals, but also penalizing people and vilifying them for raising complaints in the first place. Anyway, so I don't know anything here that is vexatious or an abuse of the court process. I mean, like it says, these are the files that it lists, and we're doing that because she hasn't given us enough of an opportunity, all factual assertions, blah, blah, blah. And I mean, I think the evidence is either relevant or irrelevant. It's either accurate or inaccurate. It has probative value or not. But even in the dictionary of the Evidence Act, vexatious is not a defined term in relation to evidence. It can be unfairly prejudicial.
Sure.
Which is a different thing, but it's a judge's job to decide that.
Absolutely.
Now, the worst aspect of what she has done, now I can prove that she got the registry. Well, I can prove through circumstantial evidence that a reasonable inference can be drawn that she did this, because here's the thing, right? They do this, and then I immediately ask them to give me a sealed copy. So because of the way they've rejected the thing, and I don't get a sealed copy, of the application.
Of the application, yeah.
Which I should. And they're not giving me a sealed copy of the application. Now, I want a sealed copy of the application because just before I emailed them, with my extensive experience with the shenanigans of the Supreme Court pathonetry, I made sure that I took a screenshot of the court filing system in relation to the status of the application that I had lodged. So I could, see if there was any tampering going on later. And this is basically a PDF document that I've put together with the screenshots. So at 10:01, before I start drafting the email, which I sent at around 10:15.
So you're talking AM here,
So,
obviously.
Yeah, AM.
Yep.
So the email that I sent to them asking for an update is at 10:16, okay?
Mm-hmm.
So just before that, I take a screenshot, and this shows that my application, which was lodged at this time, 23rd of June, 4:25 p.m., as I said previously, it was unprocessed.
Okay.
Unprocessed. This is that application. Now, at 10 o'clock, I'm asking them. 11:52, they're telling me that they rejected it yesterday. Why did they have to wait half a day and also 2 hours after I asked them for a copy of the affidavit? Because they normally respond immediately with the sealed copy, because they don't have to actually check the affidavits. That's basically it's because Justice Downs was watching the YouTube videos that were YouTube, and also she had private copies that we had exhibited to basically see whether she needed to get the registry to obstruct us from filing the evidence. And then, because I had already criticized her about this time arbitrarily listing the application, she basically saw the stuff. Maybe she saw the first video, obviously got nervous, and listed the application immediately. Okay? And again, it's the thing about corrupt people. They're generally working on instinct. Didn't fucking think things through. And then basically got the registry to backdate a rejection thing, which doesn't, it says it's vexatious and frivolous because we say it is. He doesn't even identify like which parts, but helpfully says on the face of it. She didn't give him much time to draft this bullshit thing. And again, I don't know why the Queensland Registry is dealing with this, because it should be the Victorian Registry. I know that she's from Queensland. Well, she may not have as much of a hold on people here to get them to issue fraudulent letters, but the matter is, yeah. So, I mean, it should still be coordinated through the Victorian Registry. I mean, in fairness, we have made a bunch of allegations against them, so it may be because of that. So, but again, she's that one little thing is not going to be the thing. The point is that 23rd of June, he says, obviously he hasn't made the decision then. So now I have now let me just show you one other thing. To contrast this, I took a photo at 10:30 at night. Last night, 10:30. And now I'm not looking at the unprocessed applications. There are no unprocessed applications. I'm looking at the rejected applications. Rejected applications, the top one is this one, 4:25 p.m. Okay. Then I go into the rejected application in particular. So this is how it looks. Zooming in. Again, this is 10:31 p.m. last night, 24th of June. It says that the application was processed at 11:52 a.m. on the 24th of June. Not when the letter says. Now, here's the thing. These people never received the exhibits, only she did. And I can also see who's watching the YouTube videos from the analytics. I mean, it's not that they'll name her, but the demographic details and the,
But it has to be specifically those.
You can, so firstly, we didn't send the links to anybody.
Yeah.
And we don't right now have the traffic because we haven't promoted the link. So only she had the link and the LSP had the link. And within them, you can differentiate more easily through the specifics of the analytical information and the number of times it's being watched and all of that. So she's watching those videos. And after watching all of that, she lists the application, gets them to do her dirty job because she doesn't want this stuff to be said against her in open court. Doesn't have the, I mean.
Yeah, I know. Yeah.
It's just so fucking, and the worst part of all of this is that, as I point out, corrupt judges not only induce corruption by their example and by the impunity that they grant to the people that they are basically working at the behest of, they also necessarily force other people to commit corrupt conduct under compulsion. This man lied. He's a government official, public official. He works in the fucking court. He's a judicial registrar, actually. Peter Schmidt. He lied. I say that, I mean, obviously, I'm inferring that from all of the stuff, but I'm pretty sure if I subpoena the correspondence between the judge and him, which will happen if they have the balls to charge me, it will prove with contempt. I mean, it will prove that all of this is a fucking lie. Now, she got him to lie for her benefit. That's the definition of corrupt conduct. Literally, it means all the fucking elements. It's for the particular benefit of someone. It's dishonest performance of duty.
Absolutely. But the thing is, it's not even clever.
That is actually the worst disappointment in all of this. That, not only are you fucking wasting all your time, but it's also so fucking droll. It's just fucking administrative work and she, forget about the date that she got him to lie about. She also got him to lie about the vexatious and all that bullshit. And he did that under pressure, presumably, unless she's bribing him or, well, either directly by money or some other way. But he's obviously, well, again, I'm presuming that he would have otherwise acted honestly, but forget about Peter Schmidt. Someone else, if a judge says or implies that they should do something, they do it. And I mean, the system is fucking built that way, that there's so many, subliminal programming and the authoritative thing. So this is the person who's presiding over a matter to decide whether the LSB's corrupt conduct should be punished, not whether they've committed the corrupt conduct. Everybody fucking accepts that. It's about whether they get to be excused from corrupt conduct, and she will not let us talk to give evidence in court. I mean, so now, I don't know why she listed the application, by the way. We had no basis to be heard. the application was rejected, the evidence was rejected. What's the basis for listing the thing? And I mean, okay, all facetiousness aside, the point is that she saw the fucking videos. I can prove that. Then they're relevant just because of that, because she saw them. The public should see what she saw. That's what an open hearing is. She doesn't get to see the evidence and then kick it out. And if nothing else, it's relevant. I mean, to say that the only documents that cannot be accepted are the documents that, in that respect, is something that's obviously so fucking scandalous. And I can't think of anything that could meet that requirement in terms of evidence, because, like, the court hears matters about genocides, war crimes.
Her job to do that in hearing.
Yeah, but I mean, if you can't file evidence because it's fucking unpalatable.
I'm saying it's her job to find, in regards to the evidence in the hearing. It's not the registrar's under his purview to not allow evidence.
Well, in all fairness, he's as much of a judge as she is, or anyone is as much of a judge as she is in this matter, because she's not a judge according to the law, anyway. So the point is that she does this, and then we obviously write to her and say a bunch of pleasant things. I mean, I do. And I point out all the horrible things that she's doing and blah, blah, blah. And this is the letter that Lulu put through ChatGPT because she thought it was so dense. And also, we say we're not available on the 1st of July. She never fucking checked with us the availability, and that we need a day-long hearing now because of all the other stuff that has come up. She's not letting us file the evidence, which is improper, blah, 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 and all the other things. I shouldn't mock. I put in some effort in writing this, but anyway. So today, she has the clever idea. So, I started this with Gautam. So he stopped me after some point. He would stop me from making submissions in court, because the whole point of the open hearing, that when the High Court rejected the claim of the guy who had been thrown into jail by the Federal Circuit Court judge, Salva, Stratford, I think Queensland versus Stratford is the case. They rejected that. So the federal court ruled that the Federal Circuit Court judge could be the subject of tort law proceedings for unlawfully imprisoning the person that he basically maliciously threw in jail because he was in a bad mood that day. And the High Court basically said no, because judges are too fucking precious and easily intimidated. So they should just be publicly shamed when they're wrong, and also the Court of Appeal will take care of them with their fucking acerbic criticism and all of that stuff. So that's why, since then in particular, I've made it a point to criticize it was always like that for the Superior Court judges. They also applied it to the Inferior Court judges. After that, they made the decision. I've become even bolder because it's a matter of public importance generally, that everybody understands it doesn't really work. You can't shame these fucking assholes, and they will try everything they can to stop you from doing that in public anyway. But with Gordon, I had started earlier because he's a Superior Court judge. So he would stop me from raising criticisms in open court. So I would start writing emails telling him how he's a fucking embarrassment to the judicial system, and just on that account, he's a disgrace. And he would basically defend my right to write disagreeable correspondence to him. In fact, he cites it in the orders as that being an application for the amendment of orders, just like Downs is. Anyway, so with Downs today, she basically, this is when we paused earlier, we received this email that, so a little bit earlier, she had written and said that go through the registry now. The party should go through the registry instead of emailing her. I mean, she wasn't reading the emails anyway, but by her own admission.
Yes.
But so I write back and I say, though we have previously, sorry, no, not this one. We will reply to the substance of the correspondence shortly. However, to ensure, okay, this is not, so she knew that there would be something coming because of this. However, to ensure that we act according to downstairs directions, okay. So in fairness, when I said that, I thought the directions would be lawful, but obviously they aren't. Could you please confirm whether Her Honor wishes the parties to address emails only about the interlocutory application to the Queensland Registry, or for all matters, blah, blah, blah. They wrote back and they said that for everything, you should just, dear Mr. Kutsal, now, what does that fucking mean? I don't even understand.
She going to receive them? Are you going to receive them, or just goes to?
It doesn't matter. She wasn't reading them anyway. Like maybe.
No, I wasn't reading yours.
Yeah, but this is
They're
only
happy to read the LSB.
but this is only addressed to me. It's not addressed to the parties.
No. Well, who do I write to?
Presumably her, because this is only to me.
Yeah.
So, well, you can't even write
to
me because even though we're parties, because of Gordon taking care of it. But maybe Lulu can write on my behalf, and write to Her Honor directly. If nothing else, she should at least have to delete the fucking emails and be inconvenienced to that extent. But I mean, how is this even fucking?
I don't understand. What does it achieve? So, do we know that the emails get sent to her afterwards, or does the registrar then give his version of what the email says to her, or what?
This is discrimination under the law. Like, everybody else gets to write to the chambers, and for some inexplicable reason, I can't. And it's just addressed to me. It's because of the mean emails that I've been writing. It's just so fucking pathetic. Like, how do you bully a judge? Isn't that what the whole fucking contempt charge is supposed to be?
No, it's quite extraordinary.
I mean, they have separate rules for corrupt judges somewhere, which I'm not privy to be fair. But I didn't know that you could shame a judge into not receiving your emails while they maintain jurisdiction over the matter. So anyway, basically, she stopped us from filing evidence.
Yes.
And now she won't even receive email.
Yeah.
I mean, she never was, but officially now I can't even write. So later on, I raise it elsewhere in appeal or whatever. Okay. You know why she did it? Because I wrote earlier that everything we're writing, we're going to publish anyway.
Right.
So fucking predictable. Like she's,
Oh, so an attempt to keep her name off the email.
No, well, Lulu will write for me. She's not been. Also, I don't give a shit. I will clarify that she needs to basically make an order and threaten me with contempt for me to actually take any of this seriously, because this is, and I want reasons. I'm gonna ask her for reasons why she is.
Fair enough too.
Why
she's selecting you?
Yeah.
Out and why the LSB can.
Well, you also can technically, but yours will not be read. But anyway, the point is that I mean, I've gone through a fair number of authorities, as everybody likes to point out on the other side, because I made them go through it too. And, you know, if they wanted to go through authorities, they wouldn't fucking work with the LSP. But the point is that I don't know of any precedent that that says that the judge can, you know, delegate some of the like communication channel to the registry without any basis. And I mean, if I'm doing the wrong thing, they should at least point that out so I can, you know, not do it or whatever. But it's just so fucking scandalous. Anyway, so this is obviously not just you know, a personal matter. It's really about how the
Not personal. No, I agree.
LSP is able to embed its tentacles into the judicial framework to evade accountability. I mean, never have they even said, how dare you raise these allegations? And they've also pointed out that they've not filed any evidence in support of, in response to all of the evidence that we've filed. And the only effort that they've made is basically intimidating our witnesses to stay out of court. But beyond that, there's no way conduct like this can continue to operate in a system where people like me are shaming her. Because, you know, so long as it's under the wraps, people don't get offended overtly. And, you know, it's always that, even if this person was wrong, maybe if they could have done this or that, the thing would have worked, you know, like on technicalities or on whatever. But what I do is make sure that everybody knows that I'm doing what should have been done. And the judge also does. So there's no other explanation but blatant fucking corruption that they rule the way they do. So
I don't think they understand how thorough you are. Well, I don't think they understand how thorough, or they certainly probably have seen it, how thorough you really are in respect of how you attack these matters. I mean you analyse to the nth degree, and every document that comes in is analysed and looked at. So,
I mean, I wanted to do this for many years, and for the first few years, I studied all sorts of things, not just the law, but about judicial training, about cognitive psychology, about all sorts of nuanced matters relevant to the work that I'm doing of basically forensically analyzing evidence that can demonstrate corruption and identifying patterns through which such evidence can be reliably discovered. What they don't realize is that it's all very predictable, the way people go about corruption, both in terms of the genetics of it, but also because the systems are so exhaustive in terms of data collection, the way in which you will go about destroying evidence and tampering with evidence is very predictable. And if the other party is consciously looking out for it, you will get fucked, you know? And that's why, that's the other reason I'm abusive to people like that, because I really want to show everybody that there is no fucking way that these people can survive if you're doing your job thoroughly. And that's why I'm not concerned or scared. And I mean, there's a part of the fact that I don't really believe in the sanctity of life, so it makes it easier. But anyway, the point is that we'll file this again with the constitution notice and circulate it to everybody. See if you know, enough people get outraged by this. Okay, I'll speak with you later.
No problem.
Cheers.
Okay,
bye.
good to speak. Cheers. Bye.